we now move on to the Memorandum of Incorporation. The Memorandum of Incorporation basically shows the powers of the company and its directors. What can happen is that the company can specifically adopt the standard templates which are contained in the Companies Act, or, if required, it can have its own Memorandum of Incorporation specifically drawn for its own needs of the company and specifically drafted for the company. If the Memorandum of Incorporation is modified, or if we're using a unique MOI, it is invalid to the extent that it will conflict with the basic provisions of the Companies Act. You have to understand that the Companies Act at all times will remain supreme. An MOI may include any matter that the Act does not specifically address. In other words, it's adding to the Companies Act. And it may alter any alterable provision within the Companies Act. It may impose more onerous requirements on the company and its directors than the Companies Act itself does, so long as these do not, again, conflict with the unalterable provisions of the Companies Act. An unalterable provision of the Companies Act is a provision that does not indicate that it may be altered through the Memorandum of Incorporation in any other way. So the Companies Act has got to specifically state this. Now we move on to section 13.3, and it says that the Memorandum of Incorporation may also include so-called restrictive provisions. These are provisions that would restrict the operations of the company or its directors in some or other way. 13.3 then continues, it says, where this is the case, the notice of incorporation must make a prominent statement drawing attention to restrictive provisions that are located within the MOI. We can't just hold them away somewhere hoping that the public will not notice. And then the moment that we've altered the MOI with a restrictive provision, we have to put the expression RF immediately after the company's name. That's section 19.5. RF stands for ring-fenced, and the reason for that is that we want to draw the attention of third parties to the fact that the company is ring-fenced from the normal provisions, and the basic idea is watch out, there might be more to dealing with this company than immediately meets the eye. Section 16, remember, says any amendment to the Memorandum of Incorporation must be filed with the Commission. You can't simply make a change and keep quiet on it. It's got to be immediately filed. And the MOI can only be altered in compliance with an order of court or by means of a special resolution proposed by the shareholders and adopted by the shareholders. Simply put, the directors of a company cannot just go out there and change the MOI. Section 16 continues and says the board may make changes to the authorized or unissued share capital of the company unless there is a restrictive provision within the MOI which denies them that right. However, if they do so, they must now file a notice of amendment of the MOI concerning what they have done with the share capital of the company and set out the changes that have been effected by the board of directors.